That's not the remit of the Election Commission. Assume jurisdiction where you don't have it, and you decide the matter on the basis of that. Well, this is most unfair, Mullahs. So the very assumption of jurisdiction is wrong. And then, Mullahs, our symbol is taken away. A new government is formed, entirely according to me illegal, but then that's an old story. Nothing can be done about it. If you decide the Election Commission issue first, namely who is the party, Mullahs, this court has now held that it is illegal. Mullahs, that finding is already there.
Order of disqualification, either by the speaker or when it is upheld by your lordships, relates back, my lord, to the date on which the prohibited conduct occurs. Right, my lord? Now, my lords, the decision, whatever your lordships will render in the disqualification case, has a direct impact on my symbol dispute. Then, my lord, in the Sibal'S order, which comes, my lord, on February 2023.
So therefore, Mullahs, obviously it was convenient to discard the 2018 constitution because the commission could not have decided based on legislature. So conveniently discard it, say it's not on my record, go to the 1999 constitution, say 99 constitution doesn't have any of these things, not this Karyakarani, not this organization structure. I won't look at it. Therefore, I won't look at the organization. Therefore, I'll go by the legislative majority. Well, how can a commission do that when both parties are saying that we are working under the 2018 constitution? Under what jurisdiction is the commission saying that? And under what law, Mullahs? I will demonstrate to your lordships, Mullahs, when I read 29A and the guidelines of the commission, they have no jurisdiction. And it's now there's a division bench judgment of the Delhi High Court which says that they have no adjudicatory power. They can't decide on the validity of the constitution. The maximum power they have is to withdraw the registration. And that's also an exception. That will be adjudicated. But they can't say your constitution is bad. And that under paragraph 15, when there's no jurisdiction to deal with it.
Democratic deficit, how can that?
They say there's a democratic deficit. All right, then you just recommend to us that, look, correct it. And we say, no, all other constitutions, my lordship knows, Mullahs, all other constitutions have the same kind of provisions, but I'm not going to that because that's not the remit of the Election Commission. So you assume jurisdiction where you don't have it, and you decide the matter on the basis of that. Mullahs, this is most unfair, Mullahs. That's why, Mullahs, institutions ultimately, if they don't inspire confidence, this is what happens. Anyway, 8th of October, 2022. The Election Commission passed an interim order in dispute number 1 of 2022, freezing the name of Shiv Sena and the symbol bow and arrow. The parties were also directed to furnish their proposed alternative names and symbols. I won't go into that, Mullahs. Then on 10/10/22, petitioner allotted the name Shiv Sena Uddhav Barasaheb Thackeray and the symbol flaming torch by the Election Commission by way of an interim order. And 11/10/2022, respondent was allotted the name Balasaheb Banchi Shiv Sena and the symbol दो तलवारें और एक ढाल, 2 swords and a shield, by the Election Commission by way of an interim order. That also we need not go into now. Now come, Mullahs, 17/2/2023. The Honorable Election Commission of India passed its order in dispute number such and such, allotting the party name Shiv Sena and the party symbol bow and arrow to the group led by Eknath Shinde. So the faction of the legislator now becomes, Mullahs, the party. Mullahs, next point to be considered is whether a split in the legislative wing of the party results in a split in the party itself. Wrong question, so you'll find the wrong answer. It is stated that under paragraph 15 of the Sibal'S order, the commission adjudicates a dispute when rival groups emerge in a recognized political party. The recognition is dependent upon the electoral performance of the concerned political party, as explained in paragraph 6A and 6B of the Sibal'S order. And then they, Mullahs, refer to this judgment. This is very interesting, Mullahs. I'll read this. Kindly see, he relies upon the Kerala Congress case. The first indicator of the emergence of a split in the KCM was holding of a separate state steering committee by both the groups in relation to the by-election held for 93 Pala Assembly constituency. On behalf of the respondent, it has been submitted that in the state steering committee meeting held on 23/8/2019, it was decided that the party would not contest the said by-election. On the other hand, it has been submitted on behalf of the petitioner that another meeting of the State Steering Committee was held on 38, wherein it was decided that the party would contest the by-election. So this was a dispute between two factions, two rival factions in the party. How does the judge rely upon this? In addition, on the basis of the affidavit submitted by both the parties showing their support in the legislative wing and the organizational wing, it appears clear that there are two rival factions. So, Mullahs, he relies upon a judgment which says the opposite. And then he says, Mullahs, the judge, therefore, there is no doubt in the fact that the legislative wing of the party has split into two factions, led by the petitioner and the respondent. Similarly, a split in the organizational wing of the party is also seen. Both the parties claimed a majority support of the state committee and submitted affidavits of members. So clearly, Mullahs, this was a split within the organizational wing and the party. So, Mullahs, this is one judgment he relies upon. Quoted these judgments, see what he says in paragraph 70. In view of the aforesaid facts, the Commission is of the view that there is a split not only occurred in the legislative wing of Shiv Sena, but in the party itself. See the last line. On 21/6/22, separate meetings were held by both factions. There was a clear tussle as to who was the leader of the what? Ex facie, Mullahs. So, Mullahs, my submission is going to be the Election Commission could not have assumed jurisdiction. Because he has, as I read to your Lordship's paragraph 15 yesterday, he has to come to the conclusion and be satisfied that circumstances exist and that there is material that is available for him to come to a conclusion that there is a prima facie, there is a split in the political party. And all he relies upon is 21st of June. There is no semblance of any split in the party on the 21st of June. And I've shown your Lordship those resolutions. So the very assumption of jurisdiction is wrong. And then, Mullahs, our symbol is taken away. Everything is taken away. A new government is formed entirely according to me illegal. But then that's an old story. Nothing can be done about it. But that's what happens. And the reason for that, Mullahs, may I say, with some hesitation, if you decide the Election Commission issue first, namely who is the party, and not decide the disqualification, you will get into this problem. Because later, if you decide the disqualification, you know, the horse is already bolted from the stable. Because you have already given him the symbol. But this argument of mine was rejected by 5 judges. I have to honestly say that. I said, don't do this. Please wait for the disqualification. So the result was disqualification. Reply is filed in 23. This all is decided beforehand by the Commission, and we are left, Mullahs, in a lurch. That's what it is. And this is
What survives in this case, at best, maybe the symbols order.
That's right.
Because the disqualification, etc., after the assembly having been superseded by a new assembly, really becomes academic.
No, I agree. I myself said it right in the beginning, Mullahs.
We are trying to.
But it has a bearing, Mullahs.
Absolutely, it has a bearing because both of them overlap.
Yes.
But they overlap as held in the Constitution bench on different fulcrum. The facts overlap, but the inquiry before a speaker for disqualification is a different test.
No, but it will overlap still, Mullahs.
Before the CEC for symbols is a different test.
No, with this.
Overlap of facts, but the questions which the tribunal need to answer are different. Like when you see the disqualification, the foundation precedent is satisfaction of Rule 3 and Rule 4. So that whether the person against whom a prayer for disqualification is made is demonstrated, either in fact or by conduct, that he has given up membership, he has given up voluntarily the membership of the party. Again, the Constitution bench holds voluntary giving up of membership in the legislature is not an automatic severance of relationship in the political party itself. So in this parameter, the tests which the Election Commission is going to apply would be different from the test which the speaker would apply.
Malaz, may I respond?
What you would.
May I respond? May I respond to that? May I respond to that, Malaz?
It's not a conclusion. Please don't treat it as a conclusion.
No, I know that, Malaz. I mean, we never assume any of that, Malaz. Till the last minute, till your last minute, your lordships are contemplating. Till the last minute, your lordships.
Is to have a dialogue.
Without that, there can be no Malaz.
View.
I-
When a judge plays a devil's advocate,
Yes,
becomes a binding precedent.
I agree with you entirely, Malaz. And that's why, Malaz, with candor, I will respond. Now, look at it this way, Malaz. Your lordship is right. Malaz, there is a disqualification petition, Malaz, which was filed on 23rd. The law on the subject. Let me try and respond to that, Malaz. The law on the subject is that if a disqualification petition is decided, it will relate back to the day that you have given up, voluntarily, Malaz, given up membership of the party. So if this petition were to be decided, it would go back to 21st of June. If it goes back to 21st of June, then the question of even going to the commission doesn't arise.
That is, we would like a clarity on this point. Because Mr. Sibbal, going through Subhash Desai, actually the Justice Chandrachud speaking for the bench makes an observation that voluntary giving up of membership under Rule 3 is not an automatic severance of tie in the political party outside the law.
Disowning the political.
Well, I'm not disputing that.
Now, if that is not so,
I'm not disputing that.
we fully understand your prioritization of the two exercises. That please have the disqualification first and thereafter go for the symbol.
We've lost that, Malaz, so I can't possibly argue.
Academic in this particular case.
Yes, yes.
In another case, it's an open
See.
question.
Well, is that
But if you see it as it stands in the facts of this case,
right?
what does the speaker decide? The speaker decides with regard to conduct of Eknath Shinde and his faction in June 2020.
Right.
Whether, firstly, not responding to a notice of the Pramukh to attend a meeting would amount to a act of.
That's only one. That's only one thing.
Just
Many things.
allow us to recount and correct us if we are correctly getting the facts. First is the act of the notice
Right.
that they were given notice for Paksh Pramukh's residence, they have to come. They, according to you, chose not.
That's right.
So that is a conduct which is in the nature of a challenge being thrown to the Pramukh and voluntary giving up of membership. Next is they block move to a different state and allegedly hobnob with members of another political party. From that, move to another state and do the likewise. These are the two events which premise the disqualification.
No, more, Malaz, more. More, not just that much. Passing of a resolution, appointing their own person as the whip. Well, many more instances. They appoint, Malaz.
Yes.
Sunil Prabhu they remove, and Gogavale they appoint.
Gogavale is
They appoint another Malaz in voluntarily giving up membership. Right? He appoints himself as the leader of the legislature.
These are after the application of disqualification.
That doesn't matter, Malaz. The court says
It matters. No, it matters. When you see disqualification, facts, subsequent facts are not to be taken into consideration.
Malad, this court has now held that it is illegal. Malad, that finding is already there. Malad, there, once it is illegal,
Mr. Simbal, what this court in Subhash Desai decides is not disqualification, but the decision of a faction in the legislative party appointing a whip or appointing the leader of the legislative party. This court holds that there is a connect between the legislative party and the parliamentary party is actually the superstructure on which the legislative party stands. And therefore, who would be the leader of the legislative party? It's the premise of the political party.
no, Malad, I just,
Where they strike down Mr. Shinde and his group's decision to change Mr. Thackeray's choice of Mr. Prabhu as the whip and so and so. That is one part of this case. The other part of the case gets remanded. There are three
no,
parts.
Malad, thereafter, Malad, just one more fact, Malad. 16 people, against 16 people, we move on the 23rd. The balance people, we moved on 22nd of July. So it's not just those two facts, Malad. We file it, kindly see.
We'll have to decide this.
That's right. For only 16, so that the facts are clear. We move against 16 on the 23rd of June. We move against the balance on the 2nd of July. So therefore, all events prior to 2nd of July, which will include what I have mentioned to your lordships.
Sharad Pawar case, Sharad Pawar's decision delivered by this court.
Yes, yes,
There
yes.
are two judgments.
Yes, yes.
In that decision, this court clearly holds Justice Bhushan's judgment,
Yes.
not subsequent
Sharad
events.
Yadav, Malad. Sharad Yadav's case, Malad.
Sharad Yadav's case.
So I
Sorry,
argue that matter, Mullah, myself.
my mistake. In Sharad Yadav's case, this court has held it would be the date on which you make the application.
Correct. So the
Application,
2nd of July.
prior to that have to be.
But 2nd July, I'm telling your lordships, Mullah. But I'm saying that to your lordships. 2nd of July.
Consider
No, no, 2nd of July, Mullah.
that if you are saying that it's a continuum of events,
No, no, I'm not saying. If you let's assume,
events will also
Well, I-
color the conduct.
for my purposes, I don't have to go into this. There's a disqualification application on 2nd July.
Another tranche of disqualification.
Yes, on the 2nd of July. So the very logic that your lordships is yes, will apply then.
What I am talking of is the 16 bag.
Yes, well, let's go.
That will be only in respect of the.
Doesn't matter. All right.
But
But then what, the 2nd of July?
you can incorporate.
Then 27th June also. 23rd June, 27th June, and 2nd July.
Coming back to the symbols order, because the disqualification really, apart from maybe if you ask us that the findings are correct or not, really it will not have any impact on the decision.
No, but the speaker has decided against us. So he couldn't have, we are in appeal against that order. Yes, we are in appeal against that order.
It's infructuous because the decision.
No, no, I'm sorry. This will always stand in the way as a judicial decision. We are in appeal against that order. Your lordships will have to, you may say it has become infructuous because, but your lordships will have to still set aside that decision. That's my submission to your lordship. That's all that I'm saying.
I beg to appear in the connected matter, just to, my lord,
The disqualification.
yes, on the disqualification, my lord. Lord, your lordships have held, my lord, by a constitution bench in Rana, that, my lord, the order of disqualification, either by the speaker or when it is upheld by your lordships, relates back, my lord, to the date on which the prohibited conduct occurs. Right, my lord? Now, my lords, the decision, whatever your lordships will render in the disqualification case, has a direct impact on my symbol dispute, because as on the date of 22nd of June, they stand disqualified.
That's right.
Then, my lord, in the symbols order, which comes, my lord, on February 2023, the Election Commission, my lord, could not have relied upon legislative majority.
Well, Mr. Kamath,
Yes, Lord.
this is the argument which we would request you
Yes.
to test in light of the earlier Subhash Desai judgment,
Yes, my lord.
where it says that the decision to disqualify a member on voluntarily giving up membership in the legislative party does not automatically amount to an ejection of the member
Correct, my lord.
from the political.
We don't dispute that. We don't
It
dispute.
is not so.
We don't dispute that, Malad.
Mr. Shinde, even if disqualified from the legislative party, continues to be a member.
No
of
difficulty, my lord.
Shiv
But
Sena
the
party.
problem is the election commission in deciding the symbol says that he is a majority of the legislators.
That
And
point-
therefore, my lord,
That's the point.
That's the only point on which the election commission has given the symbol.
That point today in this case does not become relevant because the decision had not been taken.
No, my lords. By your lordship's judgment, by a constitution
So
bench,
you want to say that if we
Yes.
upturn that it goes
it
back.
goes
to-
back, my lord. It goes back.
That's why I'm saying you'll have to decide this matter. This is an appeal, Malad. This will have to be decided. You may not, you may. Yes.
Lord Rana, I'll give the paragraphs.
Not just Rana, there's another three.
And also,
Well,
There is no doubt
Yes.
because the Chandrachud makes two comments on Rana.
yes, my lord.
One is, it is true that we have to decide the disqualification. The question was, as both of you would be appearing there, that whether they could participate in
In
the
the
floor
legislature.
test or not when the.
yeah, then they said, no, that you cannot injunct. Yes.
That the bench holds.
Yes.
that The decision operates prospectively.
That is
Yeah,
in
but-
respect of
Gets
180.
back to the-
That's in respect of 189. There's nothing to do with this, Malad. Your Lordship is right, but that's nothing to do with this issue. So this appeal is live because the whole election symbol is granted on this fashion. That's why it's live. Of course, 23rd June, 27th June, 3rd July. And then 21B. Malad, and then 21B, 5th July, 21B is when they vote against we are the party at that stage. So 21B also will apply. But that's now sidelined because a new election has taken place.
That cushion is gone.
Yes. Therefore, Malad, this matter will have to be decided because the basis of the commission is that. I mean, we cannot get any relief on that. Means he can't be.
Would incidentally get a relief. with the
Yes,
symbol.
exactly.
माननीय सुप्रीम कोर्ट में हुई इस महाबहस के बाद अब शिवसेना विवाद एक बेहद दिलचस्प मोड़ पर आ चुका है। वरिष्ठ अधिवक्ता कपिल सिब्बल के इन तीखे तर्कों और माननीय सुप्रीम कोर्ट की इस अहम टिप्पणी पर आपकी क्या राय है? आपको क्या लगता है असली शिवसेना कौन है? नीचे कमेंट्स बॉक्स में अपनी राय हमें जरूर बताएं। जय हिंद दोस्तों।